Good morning, members. The meeting of the Bills Committee on the Interception of Communications and Surveillance Amendment Bill 2015 is now called to order. The officials are the Deputy Secretary for Security, Ms. Mimi Lee, Mrs. Millie Ng, Principal Assistant Secretary for Security, Ms. Emily Ng, Assistant Secretary for Security, Mr. Godfrey Khan, Senior Assistant Solicitor General, and Ms. Monica Law, Senior Assistant Law Draftsman. Welcome to you all. At our previous meeting, we discussed the paper provided by the administration in response to the questions asked at the meetings of the 9th of April and the 2nd of May, and the paper number is CB2-1391-1415 bracket 01, Appendix or Annex B rather. The Annex mainly deals with items outside the scope of the bill. Members also asked for further information from the administration in respect of the numbers of cases in which the law enforcement agencies apply to the court to obtain a warrant to search or obtain information from ISPs. And the reply by the administration is in paper CB2-1572-1415 bracket 01. Members may refer to this paper or to these papers. In fact, we did discuss the paper in respect of collecting or obtaining information from ISPs and also getting his court warrant. Maybe the Deputy Secretary can introduce the paper briefly. Thank you, Chairman. I think I would like to clarify several concepts with regard to the daily investigation done by LEAs. They do, from time to time, contact institutions and individuals who can provide information to them. The ISPs are of no difference in this kind of contact. But the information is related to metadata. Say, for example, the name of the user, the ISP address, or the IP address rather. But if personal information is required, then they will apply for a warrant. That is through the judicial channel. And when they obtain a search warrant for the content, that process is not related to the ICSO. Now, the use of the warrant is not interception. And the ICSO has a clear definition for interception of communications. Yet, we do provide information to members, as we did in the past. Members also ask for data in respect of LEAs obtaining information. That's about the data. And that's about just this. This is similar to the statistics of how many witnesses they have interviewed. And they have also they have not kept such numbers, and they have also not kept numbers in respect of application for warrants for searching content information. Yet we also provided the data for LEAs obtaining data from ISPs. The police, the CNS, and the ICAC have provided the numbers. In our paper, we have also provided the procedures for the application and issue of warrants. Now you can see the requirements set out by the magistrates. The application procedure is not covered by the ordinance, the ICSO. In other ordinances, there are requirements for applying for warrants, and these things have no direct relationship with the ICSO. Yet, we hope that information we have provided will enable members to consider the bill. Thank you, the Deputy Secretary. Now you may refer to the annexes. And the information covers the obtaining of information from ISPs and also the application for search warrant from the court. They are outside the scope of the bill. In fact, they are related to the privacy, personal privacy information ordinance. Are you referring to paragraphs 4 and 5? Now you say there is no number in respect of application for warrants. What about the LEAs don't have the number, but what about the magistrates or magistracies? Well, we just contacted the LEAs. If Mr. Sin wants to obtain further information, we may inquire about it. They apply to the magistracies, right? Yes, indeed. So you may ask the magistracy.
So you will know the number of approval and rejection, right? So you want to get those numbers? So one would go to make an application. If you cannot get the figure from the applicants, then you can get the figure from the authority that he's making application with. Mr. Ho? First of all, I do not accept the explanation in this paper. It says that it has nothing to do with the ICSO. At the last meeting, we discussed this. That is, when you intercept communication, yes, it's instantly, but if you get the content, it's not instantly. Still, you get the contents of the communication. Yes, that may be under the personal data privacy ordinance. But from our perspective, we want to protect people's privacy when it comes to communication. So both pieces of legislation should be involved. ICSO and PDPO are both about privacy. Otherwise, you can do whatever kind of interception you like. So if you say it's not related to ICSO, I do not accept that. Administratively, I understand that there are different agencies that are responsible. However, I think that Ms. Mimi Lee should have the responsibility to look up the information for us. I support what Mr. Sin Chung Kai says, that is, you should ask the magistracy for the number of approval and rejection. As for the figures, just now the Deputy Secretary has already agreed to provide us with more information. Now we are a Bills Committee. We are not looking at the policy, because this involves another piece of legislation. So I don't think that is not what this Bills Committee should be looking at. I understand that members are very concerned about these issues, so I hope the government will give us the reference information and explanation. But while we scrutinize the bill, we will look at the present bill. Mr. Sin Chung Kai? Chairman, I only partly agree with you. But for the nature of the issue is related. Yes, at the moment of interception is under the ICSO. But we are talking about e-communications. It's not like letters in the past. When you intercept letters, it's different. Now for e-communications, I may not be able to intercept at that particular moment. So afterwards, I have to apply for a warrant to search for that information. This is not what this piece of legislation is about, but I want to look at it from a comprehensive angle. We scrutinize this bill, so we just look at the provisions in this bill. So with regard to ISP and the application for warrants, do you have any other questions? Well, we need the figures first. Yes, we will wait for the figures. Any other questions? Mr. Ho, I would like to ask another question. In the annex, some figures are given to us. That is about the LEAs and the request of login record and IP addresses from overseas jurisdictions. Yes, I understand that there are thousands of times, so it's impossible for you to give me the relevant details. But Ms. Mimi Lee, can you tell us what kind of issue they are roughly about? For example, the Customs and Excise Department, why are they asking the overseas ISPs for information? What is the nature of the information? According to the information provided to us by the police, when they contact the ISPs for user information, mainly it's about technology crime and crime committed online. Members may refer to paragraph 2 of our reply. It has listed a number of crimes. For example, pedophilia, nude chat, e-trade, scam, etc. As for the Customs and Excise Department, it hasn't given us much details. However, the Customs and Excise Department has a different role from that of the police. For example, they would look at copyright infringement, and if there is such kind of activity online, they would contact the ISP. This is one of the examples. Yes, I have read paragraph 2, but I do not know which one is more prevalent. You just have a list of possible offenses. We can imagine this. But Ms. Mimi Lee, do you have further information that can be provided to us? For example, if the police tries to get the information, would it mainly be involving pedophilia, or would it be about e-trade scams? I am not asking you for a breakdown of different crimes. I'm sure you do not have it, but do you have a rough idea? Deputy Secretary? Well, we may have to go back and take a look. That is, when it comes to technology crime, whether the LEAs have a detailed breakdown. And then we will look at the different figures and try to find out which crimes account for the biggest part. I think they might have such figures, and more information can be provided to Mr. Ho. We will follow up on this. Okay, we will await your information then. But I would like to reiterate that we should be focusing on these pieces of legislation. So we have looked at this paper, and if there are no other follow-up questions, then let us go back to CB bracket 2 1319 / 1415 bracket 01 Annex A. And we can discuss this relevant paper. Let us look at Annex A. Deputy Secretary, do you want to brief us on this paper? Chairman, which paper are you talking about? I'm talking about Annex A of CB bracket 2 1319 1415 bracket 01. Earlier on, we focused our discussion on issues that are not related to this bill. Now let us go back to the relevance part. Annex A provide expressly that the Commissioner may require any public office or any other person to provide any protected product in his possession to the Commissioner, including any protected product that contains journalistic material. And second, whether overseas supervisory bodies have express authority to check protected products. Do you want to supplement? Thank you, Chairman. In fact, this is one of our most important proposals. That is to provide expressively that the Commissioner may require any public officer or any other person to provide any protected products in his possession to the Commissioner. So for protected products, it may also include journalistic material and material or information subject to LPP. Under Section 53, the Commissioner is already empowered to carry out a number of overseeing activities. However, in 2009, the former Commissioner thought that if this can be expressly provided in the law, that is, he can come into direct contact with any protected product, then he can do his work much better. And when it comes to LEAs abusing any systems or hiding any information from the Commissioner, the deterrent effects will be much greater if he is given such an express power. So that's why we are making this suggestion. I would also like to stress that although in the bill we have not expressly stated that JMs should be included, but that should be included. That is, any protected product would cover JM. And the Commissioner, when he asks for such information, he can also ensure whether the LEAs have complied with the relevant requirements. So this is one of the most important suggestions that we are making for this amendment. Yes, members, with regard to Annex A, do you have any views concerning this express power and our protected products? Mr. James Toh. There is one thing that I find it difficult to accept. No matter whether it's the chairman or the administration, they are saying that, well, if a piece of information cannot be intercepted, then after 1 second, the LEA can apply for a search warrant and it can go to the ISP, and that would be a more lenient channel. That is the warrant. Then he can get the information that he didn't get 1 second ago through interception. Because for interception of communication, the relevant requirements are much more stringent. So is there still an incentive for the LEA to make an application under the ICSO because it's more stringent? Now we are amending this ordinance. The focus should be like this. That is, when we amend the ICSO, should we make the coverage bigger? That is, immediately after the failure of interception, the LEA should not be allowed to go to the ISP directly. Otherwise, nobody will be invoking the ICSO. And all the LEAs would use the warrant channel. So initially, we wanted to protect privacy with the highest standard, but by doing so, we cannot achieve such a goal. I stuttered because I want to make it very clear that we are looking at this issue. Ms. Sit-Ho and Mr. Seng Chung-kai are very concerned about this. That is, after the implementation of the ordinance, that is, in the past few years, we have seen problems. And now LEAs gradually get to know that it's too troublesome to make application under the ICSO. And when Justice Wu was in office, he was very strict. And now if you use another channel, you can file the application with the magistrate, and immediately you can get a search warrant. So what kind of protection will be afforded to the public? We are amending the ordinance. And if this is indeed the situation, then we shouldn't be making piecemeal amendments or patch-ups to the ordinance, because LEAs would not use the ICSO anymore. So what's the difference? It's just 1 second. Now, if someone is shooting or diffusing an explosion, then of course you may be able to catch that second. If not, then you don't want to get into the trouble. You can just wait and then go to apply for a warrant. When you answered other members, you said that you would use it. Because for ICSO and applying for a warrant, these are very different approaches. If I am allowed to apply for a warrant, then I don't need to intercept. If we find out something that should be covered by the ISCO, however, that you miss that particular moment, then after considering other factors, you would apply for a search warrant. Then I understand this. However, now these two pieces of legislation are totally different. Well, which one is more convenient? We'll use that. Now, I'm sure that the latter one is more convenient. I think there is a comparison table, right, Chairman? That is ICSO and warrant, a comparison of the difficulties. They are of totally different nature. Well, if you ask me, I think if you make an application under the ICSO, it will be much more difficult. It has to be a serious crime, and it has to be less intrusive when it comes to privacy, and also there may be information subject to LPP involved.
Journalistic materials. The commissioner will from time to time check on the LEAs and check the products. But for the magistracy or magistrates, you have applied for a warrant. If the warrant's approved, and then that's the end of the story. Whether the information obtained is LPP or JM, the magistrate is not informed. The magistrate will not follow it up. Now the many warrants, and they say there is no categorization. You get a warrant to seize stolen goods. You apply a warrant to obtain information. you just slip a warrant amid that there's so many applications. You just slip in an application to obtain information content. Amid there's so many warrants. It can be easy to abuse. You say there is no abuse because the magistrate proves that he is a gatekeeper. But the gatekeeper does not ask you whether you should adopt the interception approach instead of obtaining the content. Mr. To, you're very experienced. I'll give the floor to the administration later, but as the chairman, I have to chair the meeting according to the scope of the bill. We need to follow the established practice. The interception of communications is a special system. It requires the LEAs to observe certain rules in the interception of electronic communications. You are referring to things which falls under another law. In fact, that is in relation to the privacy, personal data privacy ordinance. Say during interception, if it fails, after 1 minute, they can apply to the magistracy. In fact, they are doing, they can do that. I'm trying to convince the administration that if we have discovered any inadequacies, then the administration can move CSAs. The first point is that I'm trying to convince other members and also the administration to move a CSA to cover the scope of the ICSO to include the issue I raised. This is relevant. Thank you, Chairman. Let me explain two very important concepts. It is the situation of interception communication and the application for content, application for warrants to obtain the content. As for the LEAs, well, they must go through a certain process in the investigation, and it can be long and short, and usually long. Before the legislative, or rather before the criminal proceedings, there may be interviews and also collection of evidence. There's a need to adopt effective means. And interception is an effective means. This is the incentive for using the means. This approach is more invasive. Therefore, 9 years ago, when the Council enacted this ordinance, conditions are set. Conditions were set, boundaries were drawn to prevent the invasion into privacy. With regard to interception, the subject is not able to know that it is going on, and information obtained is real-time. It's not that getting the content after the event. There is no editing and no deletion because it is obtained real time. The power is great, and investigation is the interception is used as criminal intelligence. It cannot be put before the court as evidence. But when it comes to obtaining a warrant, it is at a later stage of the investigation. The LEA is of the view that evidence should be obtained so that it can be brought before the court, and the court should be satisfied with that. Then they will go to the court to get a warrant. If there is a warrant, if a warrant is applied, it's nearly a semi-open process. When you get a warrant in the morning and in the afternoon when you go to the premises, the people there may have already known that. And that is also a definite requirement. Say, for example, the content at a certain date on a certain date at a certain time. And that is already past the event. In the past 9 years, with regard to interception of communication, the LEAs have made use of that to prevent serious crimes and also investigate serious crimes. More than 2,400 criminals were arrested arising from information obtained through interception of communication. The LEAs will continue to invoke the ordinance, though the procedures are very complicated. Interception is still very effective. As for evidence that can be brought before the court, there are differences. If you obtain contents by a warrant, the contents can be brought before the court as evidence, whereas information obtained through interception may not. And the content will also be disclosed to defense, so that the defense can decide can decide on the way of making a defense. Now, if there is any impropriety in searching the information by using the warrant, it can be debated at the court. So people will not just get round the ICSO by obtaining warrants from the magistracies. Chairman, let me correct this point. Mr. Kwok is not here, and Mr. To is also referred to store and forward. Many people say that the information is stored and then forwarded. As for interception, a very important definition, part of the definition is that the information is intercepted in the process of being distributed or being transmitted. It doesn't mean that with regard to store and forward, we can go to get the content directly. I think there is a confusion here. Can you directly answer Mr. To's question? Will you consider reviewing the ordinance and then expanding the scope of the ordinance to cover the acts of obtaining information, obtaining contents from the ISPs? It's a very important point. Thank you, Chairman. With regard to the definition of interception, it is adequate. Mr. To may say that is not adequate. The technology is developing rapidly, and social media is many kinds of media are being introduced. Why don't you try to make the ordinance more adequate? Now we will monitor the operation of the bill and of the law, and if we find that the ordinance is not effective, we will start the amendment process. But we don't see the need at present. With regard to interception and also definition of the communication network, we think the definition is able to cover the things we want to intercept. So we have no intention to broaden the definition of or the scope of the bill or the ordinance, but the view, of course, is minuted, and if need be, we will refer to the members' views and further develop this. Mr. Sin Chung Kai. I don't know whether my concept is wrong or their concept is wrong. Anyways, I want to clarify this. I think my view is similar to that of Mr. To or Mr. Mok. Interception, the ICSO is an effective ordinance, but with the change of technology, the effectiveness of the ordinance is getting smaller. What does it mean? Now, the ordinance is to make sure that in the process of interception, there is a fair and just monitoring mechanism. And there have been applications, but because of change in methods of communication, the methods of other methods of communication are not covered by this ordinance. They therefore have adopted another approach. So now people make use of WeChat or WhatsApp. You don't need interception. You can obtain the content. You can obtain the information. Because interception is just done at the time of transmission. If you don't intercept, then you can use the warrant and then get the whole file. You can get the history, your communication history over the years can be obtained. And communication record includes content. That's very clear. And all these do not fall within the supervision of this ordinance. Now you say you need to get a warrant. There is a judge. But is the supervision on under that mechanism is similar? When you go to a magistrate, the magistrate just looks at a form, and will he ask tough questions? We have doubts about it. Now, with the change of methods of communication, the protection given by this ordinance is undermined. Will the administration, therefore, respond to that, therefore widening the scope, thereby widening the scope of this ordinance? If not, are there other means to protect, to strengthen the protection of privacy of citizens?
Well, to answer Mr. Sin's question, while we implement the ICSO, members of the public can still enjoy privacy, because for the definition under the ICSO is quite broad. It covers a lot of areas. It has not stated that only certain social media are covered. If you look at the definition of telecommunication systems, is very broad. It says that through an electromagnetic wave, the message is transmitted. So it covers a large area. We have internally thought carefully about this, and this definition actually is quite broad. So when it comes to legal terms, I have also mentioned this before. The definition of computer is more or less the same as that in a dictionary. Why do we not want to make it broader or narrower? Because the computer technology is developing very rapidly. We have once seen a case in the UK. It says that when you interpret the law, you have to look at the legal language. And so for a telecommunications system, we are adopting such an approach. And when it involves science or technology, provision should be regarded as always speaking. That is, when you look at the legal language, you should interpret it in the broadest manner. You should regard the language as always speaking and always evolving. Unless the result is obviously absurd or unjust. Otherwise, you would regard it as is always speaking. So we have adopted this concept and we think it is adequate. Anyway, we would like to thank Mr. Sin for his reminder. That is also quite valuable. If the technology develops to such an extent that we think this ordinance is no longer broad enough, then we will move other amendments, but this is not that time yet. I would like to explain myself once more. Why do we think that the protection is undermined? The Deputy Secretary does not agree to that. Let me cite an example. For example, 10 years ago, when there was no such an ordinance, when we look at the communication among criminals, well, I think 80 to 90% of them would use telephones. They would call each other directly. So that's why there was an interception of communication. That is to just tap the telephone line. So after 10 years, nowadays, and people and even criminals' habits have changed. 90% of the communication would be social media or WhatsApp, WeChat, and only 10% of them would use telephone. So 9 years ago, we had this piece of legislation. You protected 90% of the communication, but now you can only protect 10% of the communication. So that's why I say the protection is undermined. So how can you ensure that the 90% I mentioned will be protected? Well, in the law, it is said that the communication can be carried out in the form of mailing a letter or e-communication. Mr. Charles Mock and I think that the interception will be able to intercept information. So we are talking about that particular moment, but after that moment, you have to go to apply to an ISP, and then you have to invoke another piece of legislation. Yes, my logic is very clear. I'm talking about the protection under this piece of legislation. Communication can be protected under this ordinance, and the protection should be bigger than the protection under another piece of legislation through which you apply for a warrant. Okay, 9 years ago, 90% of the communication will be covered by this ordinance. But today, after 9 years, this ordinance can only cover 10% of the communication. Why do you think 10%? Well, it's just a guesstimate. As I explained just now, well, those are covered. Most of the people now, including criminals, do not use telephone to communicate. They would use other electronic means. So these are not covered by this communication because this is about in the course of transmission. So if I were the EIA, I would just brush this aside. I would just go to the magistracy and apply for a warrant and I can get all the contents. So if you want to do anything about that, then you should amend the PDPO. That is, a more stringent requirement should be met before a warrant can be issued. Because now we are discussing this ordinance. This ordinance should not affect the implementation of another ordinance. For the ICSO, the definition of telecommunication system is very broad. As long as it's caught under this broad definition, then the message transmitted can be intercepted. I know Mr. Sin is kindly pointing this out to us, but I don't think he's correct. Now, most people use social media, but we cannot assume that criminals would also use social media more. I don't think we can say that's correct, definitely. And for the ICSO, interception can only be carried out over serious crimes, that is, which may lead to 7 years imprisonment. The threshold is really high. If you say it is an easy path, I cannot agree. As for applying to a magistrate for a warrant, it's not that easy either. If you want to go down the judicial path, in particular when it's such an invasive device, there are also stringent requirements because the subject should also be able to enjoy certain protections. So for LEAs, under certain circumstances, they would apply for a warrant, but it doesn't mean that they are sidestepping the ICSO. Chairman, I always assume that people are kind in nature and government officials would not pretend that they do not understand members' questions. However, I still want to explain it more clearly. Now, in the past, telephone calls were not recorded. So if you fail to intercept during the course of the phone call, then you have to go to the telephone company to apply for a record, but still they do not have such a record. However, technology has advanced. Now we have WhatsApp and WeChat and all sorts of means. In the course of transmission, for example, if I'm WhatsApping the chairman now, I'm saying that after the meeting, let's go for a coffee. So when the message is being transmitted, it can be intercepted. However, when it's being transmitted, according to the law, now you still have to look at proportionality, and you have to comply with a set of rules, and you need to meet stringent requirements before you can intercept. Now, if that WhatsApp message is not stored by the ISP, then the situation will be the same as before. That is, if you want to know the communication between the two criminals, you have to intercept it. In the past, it was a voice record, it would disappear, and now it's a message. So the ISP or the software terminal would store this message. So the LEA can bypass. I'm not saying that it's illegal. However, you have an incentive not to intercept at that particular second, because after that you can go to a magistrate to apply for a warrant. And there is a premise. I and many other members think that going to a magistrate for a warrant is a lower protection because the requirements are lower. You don't look at the essentiality and the proportionality. I think the public's privacy should be protected, and we have seen overseas examples. They want to adhere to the highest standards. Some of them have included softwares into the system. I can cite an example later. And the other way of doing it is that they would amend the search rules. That is the magistracy that I'm talking about. That is, if softwares are involved, the LEAs would also have to meet a very high requirement before they can go down a channel. Chairman, I would like to cite an example. Chairman, now we are in a meeting, so we have not turned on our phone. I WhatsApp you and then I turn off my phone because you have turned off your phone, so you would not see my WhatsApp message immediately. So the ISP will store the message for a period of time. Once you turn on your phone, you will receive that WhatsApp message.
Now the untransmitted message can still be obtained by a warrant. If the LEA gets a warrant, it can go to the ISP and then get the message, which showed that 5 minutes ago I sent a message to him and asked him for tea. And in fact, you have already known the information earlier than the chairman, because the chairman has yet to switch on his mobile phone. Of course, I want you to change the law. Even if you don't change the law, would you change the law governing the search warrant? Or if you don't change that piece of law, will you try to do something to address our concern? That is, you will not deliberately make use of a lower standard to obtain the information or content. Before you change the law, at least, you will exercise some restraint through administrative means. You respect the spirit of the law, and that is to give instant communication the highest level protection in respect of personal privacy. Yes, Mr. Toh, I fully understand your point. I fully understand your example. Yet we are discussing interception of communication. And if an application is made under for a warrant, then that is through the PDPO, and you need to you have already mentioned that the government can strengthen that. Well, overseas examples, they may also strengthen the ordinance on interception. Well, I ask the administration, will you extend the power of the ordinance? You have already given the example. It's very simple. I think the PDPO will have to be changed if you expand the scope of the ICSO. Let me give you one more example so that to facilitate the consideration of the administration. Now, if you refer to instant communication, such as, for example, you will not search for that within 3 months. You can also conduct a search on that within 3 months. Say if you tell the magistrate that you are going to obtain instant communication information. We didn't do the interception because yesterday we didn't have the time to do that. So I asked the magistrate to approve the searching of information or by a warrant in respect of information of the past 5 days, then the magistrate will not give the approval. I think that you need a consequential amendment in order to achieve that. It's about whether you amend the ordinance and also amend the related provisions of other ordinances. The second question is, even if you don't make any amendment, will you say something or make a statement to address our concerns so that under the current situation, which I think is not desirable, will the LEAs exercise self-restraint or promulgate any guidelines or rules so as not to abuse the power? Thank you, Chairman. Thank you, Mr. Toh, for the question. I understand Mr. Toh's concern. He is concerned about the inadequacy of the ordinance, whether people will get around the ordinance so as to get an easy way out to obtain content of the communication. And his third point is on protecting privacy. These are important points, and I think they are relevant. As for comparison between interception and obtaining a warrant, from the point of view of the LEAs look at the need of the case in deciding on the approach, whether it is interception or application for a warrant. I do not repeat my points. I do not repeat the differences. In terms of effectiveness, in terms of the products obtained, they are very different. This is a fact. Say, for example, interception is obtained, information is obtained on real time for intelligence and for the next step of operation. As for the search warrant, it is to search for the content, it is the product, and it is for bringing the matter before the court. I want to refute the point clearly, and that is with regard to obtaining a search warrant. The application is not an easy process. The requirement is not low. It is very strict. On the contrary, the LEA has to provide a detailed application and fill in a form. And before the magistrate, there is evidence has to be given under oath, and information is put down why within a certain premises there is information which is of investigation value or investigation value. Yes, I think you are just repeating your point. I think Mr. Toh is of the view that the search warrant is too loose and it can be easily obtained. I just want to ask you whether you will widen the scope of the ordinance. Say, for example, Mr. Toh suggests a time limit. You can't obtain information in the past 1 month or past 3 months. Or you change another ordinance. Say, for example, amend the PDPO so as to achieve the effect as suggested by Mr. Toh. Please answer his question directly. You don't think that there is a lower standard with regard to the warrant. The second question is whether you will consider expanding the scope of the ordinance, and third, whether you amend it. Chairman, I want to make a supplement on one point. If we just amend the ICSO, the effect as suggested by Mr. Toh cannot be achieved, and there is a need to change the law in respect of application for warrants. My personal view is that may expand the scope of the amendment. The DS, legal advisor. In fact, the administration can expand the scope of the ordinance and gives an undertaking that they are going to amend other laws. That is exactly on the point. After you may not answer the question now, but after consideration, you may say that the scope of the ordinance can be expanded. But if you don't intend to do so, then I believe the present discussion is outside the scope of the bill. As for the concern of Mr. To, is that the ordinance is not effective in protecting privacy. Can you explain your view? It's about stored message. I think that's most important. If the information is not stored, there is no problem. If it is in respect of interception, it is different from obtaining a search warrant. The definition of the ordinance is already very broad, and the LEAs are of the view that the scope is broad enough, and therefore we have no intention to amend the definition of the ordinance. With regard to Mr. To's view, in the future, in respect of the development of the ordinance, that may be enlightening, and we hope that it will be put on record. And in conducting a review, in the further review of the ordinance, we may consider such a view. Will you expand the ordinance? It's hard to. Will you expand the scope of other ordinances? It's hard to say, and I do not have adequate information to tell you that whether we will definitely do that. But I can give the undertaking that we can bring Mr. To's view back to the authorities, and when there is any difficulty in operation of the ordinance, we will of course consider the views of Mr. To, Mr. Sin, Mr. Mok, and that will become a basis for further development. I'll give the floor to Mr. Yeo because the two other members have spoken before. I think it's very clear that the interception ordinance is for surveillance, and the warrant is for obtaining information, for bringing evidence before the court. They are two different pieces, and they have different objectives. It is very clear. And there is, if you mix them together, that will only cause confusion. If we just belabor the point, we will just drag the meeting on. The legal advisor has also put it very clearly that the discussion is on interception and communication ordinance. If you try to drag the matter on, it can be extended to many ordinances. It may be extended to cover the investigation, many kinds of investigation, and also matters to be brought before the court. Should we not therefore focus on the ordinance itself, whether there are any loopholes, and we should not extend the discussion? I think, Chairman, you better chair the meeting and focus our attention on the ordinance. Thank you, Mr. Yeo. I think it is normal to express the concern. It is reasonable to consider the difference between interception and also the search warrant. But if you want to change the arrangement, it's not just a change of this ordinance. It's also related to serious crimes and also copyrights and many other things, because the search warrant covers many things. But I agree that if the administration is of the view that it is not going to change the scope of the ordinance, then we should focus our attention on the ordinance itself. That's reasonable. Mr. Ma Fung Kwok. Thank you, Chairman. Well, I have been listening the whole morning, and I understand the concern of my colleagues. I think there are two different things. One is about going to the court, and it covers a broad scope, and there is a third party. You need the cooperation of the third party. It's about duties and powers. And I don't believe this ordinance is able to deal with that. The second point is this. Now, this is the amendment bill to the ICSO. Here, we are going to widen or strengthen the powers of supervision on LEAs and their interception behavior. The LEAs have greater obligations and responsibilities. And that is an important measure in respect of protecting privacy. It is an improvement, and I have no strong views. I don't find any serious problem with that. If there are other problems, they should be dealt with somewhere. On other occasions. As for the concerns of Mr. James Toh, with new technology, in the process of collecting evidence, there should be new powers and new obligations, and that should be considered by the relevant panels. And the administration should be ready to face up to these problems. I don't think we should belabor the point here. I don't believe the administration is able to give any undertaking on the way forward, and we should not try to get round and round with regard to these issues. Let's proceed straight on studying this ordinance.
Any response from the government? No? Mr. Sin Chung Kai. Chairman. You say that this should be followed up at other panels. Well, at the panels, we just have an hour or so to discuss such an issue, and that hour has to be shared by a dozen members. But now we are scrutinizing this bill. Yes, the scope can be narrower. However, when we look at the background behind the whole bill, it is related to what we are discussing today. If we go back to 9 years ago, when the police enforced the law, or when the LEAs enforced the law, when they intercept the public's communication, they should be subject to certain restrictions. That's what this ordinance aims to do. If you look at overseas examples, they are also doing the same thing, and it was said that Snowden was wrong, and now they discover that the surveillance system was wrong. So when we really have to look long term. Now for the ICSO, there are data, figures, surveillance, overseeing, and now we are talking about the annex. The LEAs do not have data. There's no breakdown of the data, and no one's auditing them. And how about the magistracy? You say that, yes, you will go check with the magistracy. So when you compare this two, is there anyone reviewing the warrants application procedures? Now we can't even get figures from them. So the two approaches cannot be compared. I think you should monitor it more closely. It seems that now they do not want you to put your hand in it. And there are two approaches. One is interception. So at that particular 0.01 second, you have to intercept the communication. So the LEAs would save the trouble. They would just go to apply for a warrant, and they can get whatever contents they want. And the LEAs now cannot provide us with the relevant data. The administration has agreed that they will be providing members with further information in writing. Yes, I agree that if we are all concerned about this, and we should look at it further. That is the warrant channel to lose? I think, yes, maybe we can take a look at that. Deputy Secretary. As for the provision of figures, first of all, we have undertaken that we will check with the magistracy and try to get the figures. As for the LEAs, why can't they provide such figures to members? Because the application for warrants is the work they do on a daily basis. It's like interviewing suspects, etc. So that's why they haven't compiled statistics in this regard. This is a matter of resources deployment. And also in paragraph 5, we also said that when you apply for a warrant, the judicial threshold is not that low. You have to satisfy a number of requirements. So I hope members won't have such an impression that it's very easy to get a warrant. Well, the LEA's application for warrants have been rejected by the court, so the threshold is not that low. I would like to know more about this. For the courts, how many applications have they received? How many of the applications have been rejected? And under what circumstances were the applications rejected? Well, you should give us the figures. Well, we haven't asked for those figures. Just now a member raised this issue and the government says that they will try to get those figures. Well, you said that this is just the daily work of a LEA. So that's why they don't have a record. However, I think what they do should be made accountable. I'm not talking about a particular case. I just want to see the macro picture. The public has this expectation of the LEAs, so shouldn't the LEAs be doing something to respond? Well, other than internal need, shouldn't they also be addressing the public's concern? Deputy Secretary, I don't have anything to add. Mr. James Doe, I would like to cite an example and ask a question, so that Mr. Yu Swing and Mr. Ma Fong Kwok can understand what we are talking about. And we are not talking about very different issues. The Deputy Secretary might have misled members. She said that for interception of communications is for surveillance and for investigation. And when the situation is ripe, they would search for evidence. And these are 2 stages. Sorry, Chairman. I would like to ask a simple question. So the government would only apply for a warrant when it wants to get evidence. So if the information it gets is an intelligence, does it mean that it cannot apply for a magistrate's warrant? Thank you, Mr. James Doe. It's about under what circumstances you can apply for a warrant. For an LEA, if it thinks that there is such a need to get the information, and the information that's collected will be produced at the courts, then he would have to apply for a warrant to search for that information. And when they investigate into cases, they would contact different organizations for information. Well, have you seen this? Have you seen something extraordinary? Has anything, etc.? So if they have reasonable suspicion, and if the other party does not cooperate, then they would have to apply for a warrant so as to make that person make the information available. So for the magistracy warrant, the information collected won't just be used for evidence. It can be used for investigation, right? I will cite another example, Chairman. If the drug dealers A and B, and they would be trading drugs, you might have thought, well, maybe I should intercept their communications. So if they just use an elementary device, they call each other, and if the telephone call is not recorded, then that's one thing. But now they are using WhatsApp to communicate. They want to fix the location for trading. And now you opt for warrants. You want to search the company, and you look at the WhatsApp messages over the past week. And then you discover this location of trading. They may be using a code, but you know what that code means. Then you would also check the CCTV near the location. So for the information you get, that can be used for intelligence. You are not going to use the WhatsApp as an evidence because you have to seize the drug first. So you have exactly answered Mr. Yu Siwing and Mr. Ma Feng Kwok's questions. These are not two different issues. You have not promised us that the warrants will only be used for collecting evidence. So theoretically, applications can be made every day for the retrieval of information stored with modern technology. So we want the highest level of protection, but it won't exist anymore. Of course, I cannot force you to amend it. However, I think this discussion is relevant. Well, if you are not going to amend it, I can move a CSA myself. However, I am giving you an opportunity to answer members' questions and to address the public's concern. You should give us the best justification so that there can be a discussion in society. And even if I make a CSA, I want people to know that my CSA is not unreasonable. So for the administration, if you think what we are discussing now is unreasonable, or you are telling us that if you make an application for magistracy warrants, the threshold is even higher, then tell us so. Now, if you go down the warrant path, actually, the incident is already made public. Now, because you apply for a warrant and then you go to the premises, you have to show your warrants, etc., then the criminals would know and they would evade. So would a telecommunication company tell the person that's going to be searched? Can you let her explain? Well, would a telecommunication company do that? So if my WhatsApp would be investigated, would a telecommunication company tell me? The telecommunication company has the right to disclose to the person involved his the telecommunication company is not breaking any rule. So this is about an action which would be known by people or not. A covered operation would have a different effect because this is a covered operation. So that's why under the ICSO we have to regulate the LEAs. Mr. Ma Fengkuo, I think Mr. James Cho has underestimated my understanding of the two pieces of legislation. He says that the government is trying to mislead us. I don't think so. I think the government is sincere in telling us the whole picture. Why do you think the government is misleading us? As for these two pieces of legislation, well, as far as I know, if you go to the court for a warrant, it's not just for the collection of evidence. In the course of investigation, you can also do that. The Deputy Secretary said that if you have a reasonable suspicion, then if you can convince the magistrates, then you can get a warrant. It's very simple. Why do you think there is any misleading? As for the interception of communications, I think the government has explained a lot. Well, I'm in the film industry, although I haven't made a film lately. But for a script writer, if he writes a detective story, he would know that the criminals, when they communicate, they won't say that I'm going to a certain place to get a drug. There are always codes. So for interception of communications is to assist investigations to get clues. And then afterwards, you may take further action or try to make prosecution. So if you go to the court to apply for warrants, the public would know. And the criminals would also know. So there are two sets of principles that we have to look at. As for WeChat and other means of communication, I think the script writer will write such a story in which the criminals would WeChat to each other and saying that they're going to a certain place to retrieve the drug. So for interception of communications, there is a real-time need. This is a general understanding. I think this is just common sense.
Therefore, well, I entirely share Mr. James To's concern. That's the community's concern. That's something we should pay special to which we should pay special attention. But we should not put it within. We should not use this as a digression from the ordinance. Let us discuss whether there is a need to amend the ordinance and whether the amendment is effective, whether there is a need to enhance the supervision of the LEAs. If there is, then let us pass the bill as soon as possible. I don't need any response from the administration. The application for a search warrant is different from interception. They have different objectives. They may say want to obtain intelligence. The administration has spelled out the differences between the two approaches. As for the difference in views, a difference in emphases, members have already explained expressed their views. Mr. Yu Xiuing. Yes, I thank Mr. To for raising the question. Now, the amendment bill is to enhance the supervision of the LEAs under the ICSO. And the discussion has brought up an issue in respect of the application for warrants, whether the condition thresholds are the threshold is too low, and there may be abuse. That's good to raise the question, but we need the time to put an end to the discussion. there is a thorough discussion. We understand Mr. To's concerns, and the administration has already explained the different approaches. It is very clear. There is no misleading. We are not misled. We understand where what the issues are. So let us go back to the ICSO, whether we should further the discussion on the amendment bill. As for the issue in respect of the warrant, we can discuss the matter. If need be, we can raise the question at the panel, and then we can even have an agenda item to discuss that. There is no need for us to digress into that area. Mr. James To. Chairman, I have a question in respect of the annex. Paper 1572, bracket 01. Annex concerning the numbers. Para 6. ICSA 201503, and that is the LEAs LEAs obtaining information from ISPs and also applying to court warrant. Paragraph 6, applying for court warrant. Paragraph 6. What is your question? Paragraph 6, what is your question? Statistics. Now, in the second sentence, law enforcement agencies do not keep statistics on application for court warrant for obtaining information or documents from any institution, individuals, or trade. There is no statistics. Does it mean that there is no statistic on the total number of court warrants applied, which the LEAs have applied? Does it mean that the police doesn't keep statistics on the number of applications? Yes, there is no overall statistics. How many warrants have been applied for in a year? Why there is none? It's very basic. Say for the police, they enforce the law. They apply to courts to get a warrant. They don't even have a number. I believe you don't have the breakdown, but it's impossible that they don't have the total number of court warrants they have applied for. Now, if a LEA wants to investigate a case, it may apply for N numbers of warrants. This is in the record. But if you ask them to check all the files and then count the number of warrants applied for, that will be difficult. That will be impossible for them to compile the statistics. Say, for example, the FC may ask us for numbers. If we don't have the overall statistics, then we can tell the council that we don't have the numbers. They must have that in the files, and the record is complete. The police has a heavy workload. With regard to keeping of statistics, they put emphasis on categorization of crimes, say number of arrests, number of cases charged. They have categories of crimes, which type of crime has the highest increase. They have such reports. But if you ask them how many interviews they have made, how many statements they have taken, how many warrants they have applied for, they don't keep the overall numbers. I'm really astonished, Mr. Chairman. I even suspect whether they don't have. If you look at the annex to this appendix, that is obtaining information from ISPs. It's not going to the court for a warrant for a warrant. Now, going to the court for a warrant is a statutory process. Obtaining information from ISP is a non-statutory process. and if they can provide you the information, they can give you. Now, they have the number for non-statutory procedures, 4389 by the police in 2013. But in 2013, the police doesn't have the number of warrants they have applied from the court. How can that be? Now, you ask for information from the ISPs. This is a non-statutory process. They can say no to you. But if you go to the court, you have to go through the process. You have to make the applications according to the law. Why there is no statistics of the overall number? Does it mean that here, when you go to the ISP will always give you the information, so you have the statistics. But if you don't, if you go to the court may not approve all your applications. Therefore, you don't want to keep the statistics in order not to show that most of your applications or a lot of your applications are rejected and you are approaching the matter very lightly, and you don't want to show yourself in bad light. I find it strange that they don't keep statistics. Is it because of Mr. Toe's concern? They're afraid that the court doesn't give approvals on all occasions. The approval rate is very low, and therefore you don't want to they don't want to keep the statistics. Well, we'll try to obtain the numbers from the court, see if they have consolidated numbers. We don't have the total numbers. It doesn't mean that we don't have the number for individual cases. Chairman, they say they have the numbers in each file. It's unreasonable for them to go over several thousand files to compile the statistics. But I just want to know why you have it in the appendix to the annex. Say there are several ISPs, for example, Smart Home. Will you check all the files, several thousand files? There must be some record. Well, let me explain. I hope you can be assured with regard to the number of cases for obtaining information from ISPs, the police. They obtain the information through a single unit. Through that single unit, we can get the statistics. I intended to speak on that. You don't need to be so emotional. I want to ask one more piece of information. I'm very keen on this in respect of the warrant. I'm talking about the content. You better wait for the second round. Just one word. I have to go to another meeting. Can you, within a short period of time? I don't want them to spend so much time, say half a year or 1 year. I don't know whether I'm too demanding. You have applied for a warrant. You have applied for warrants. You search the information stored by account holders of the ISPs. My concern is about getting around the law. The LEA is getting around the law. Say within half a year or within a year, we will not use a warrant to obtain store message. Then I don't need to worry. I may spend more time on making a reform. If there are many such applications, then you are not using the ICSO. Can you give us information, the Deputy Secretary? We'll liaise with the magistracies to obtain the information or statistics, and then we can also talk to the LEAs. Ms. Emily Lau, and then Mr. Paul Chen. It's also about this paper. I don't understand why the administration has the statistics for asking information from the ISPs but don't have the statistics for application for warrants. Will she provide collect information for searching search warrants? How many approved? How many not approved? We want to have the information. Can you confirm this? I confirm that I will liaise with the magistrate to obtain the information. You should have kept your records. Say, for example, the police, the CNS, the ICAC. How many warrants have they applied? They should know. And they should also know how many have been approved, how many have not approved. Now, the statistics are available in the appendix because there is a single unit which is responsible for obtaining information from the ISPs. It's through a single unit. And therefore, they can give us the numbers. As for warrants, it is the individual case officers who, at a certain stage, go to the court to apply for warrants. We therefore don't have the consolidated numbers. But we will try to approach the court to get the information. Yes, please tell the court and they can help. I think you should establish a system so that you can consolidate the data from different districts. You have several law enforcing agencies. Chairman, concerning obtaining information from ISPs. In the first paragraph, it said that the inquiry does not include content of communication which is not open. And that's it. And it has to they have to comply with the PDPO. They said that they will have to investigate many crimes, juvenile, obscene, child pornography, and naked chat. If you don't obtain the content, how can you conduct any investigation? In paragraph 2. Now, in paragraph 2, the ISP is asked to provide the IP address and also the account number, the account user name, and also login record. They are meta information. If it's about content, it is not under the scope. It's not within the scope. I would like to provide further information for Ms. Lau. If it is in respect of child pornography, deception, social media, deception, naked chat, the ISPs are very anxious about it. They don't want such things to happen in their network. So according to our experience, the ISPs are willing to provide information so as to clarify the relationship between the ISP and these cases.
So they have to give everything to you. That's why I want to clarify. You say that they are willing to provide information, but that does not include the content, right? Do they provide you with the content? If we want the contents, we need to rely on a warrant. They have to apply to the court for a warrant first. So for the assistance you mentioned, it's just about what you said, right? So not including the content, right? Mr. Jean-Jacques, are we talking about two issues? I can cite an example. Now, if we ask a telephone company to provide us with the username and reference information, then that is one approach, and intercepting the contents is another issue. So for IP address, username, they are just a registration record. So this is just a superficial level. And the privacy infringement is less serious. So that's why the ISPs are willing to provide that information, and you do not need a warrant for that. Yes, I can confirm that understanding. So after getting the information, you make an initial analysis, and if you think that you need to get the content, then you have to apply to the court for a warrant. And this would, you have to go through more stringent procedures, right? Well, if it's about getting the contents and applying for warrants under general circumstances, the contents will be used at courts. So would that be superficial? Superficial. So how about interfigures? As for interfigures, the LEAs haven't kept such statistics, and they are distributed in tens of thousands of files. So we will try to check with the magistracy and see if they have compiled some figures. Let's not talk about the internet or IP address. In the past, if you wanted to get personal information or company documents, you just have to look at all the files, right? Yes. So even the judiciary does not have such a record, right? Do you know about that? I don't know about that. Well, can you go back and find out? It seems that I'm interrogating you. This is my bad habit, but I can get precise information from you then. I just heard Mr. James Toll and also other members mentioned it too. On one hand, I would like to thank Mr. Toll for asking such questions. However, at the same time, maybe he's over-worrying because there's no evidence showing that criminals in Hong Kong are so stupid. That is, they would use the internet to communicate. Now, have you watched this kind of movies? When we talk about the triad bosses, when they go to sauna, and when they are totally naked, immersed in hot water, they would talk about this kind of thing. I don't think they would use internet to talk about secrets because a trail will be left. I think Mr. James Toll has always been quite imaginative. Yeah, sometimes imagination is useful. However, sometimes we may not need to go that far. Does the Deputy Secretary want to respond to this point? Do you think criminals will be using WhatsApp to talk about their plan for bank robbery? We would like to thank Mr. James Toll for his comments. We also are grateful for other members' comments. Well, although his comments may not form a basis for immediate amendments to the ordinance, but that may be useful in the future. Ms. Claudia Mo? Thank you, Chairman. I think the public thinks that this bill covers too huge a scope. It seems that you can do everything you like. Now, there is a warrant, so you can go to apply for a warrant. That is also a possible channel. Just now, you talked about superficial information and content. So, superficially, you think it's very easy. However, in mainland China, a reporter called C2 sent an email. And it said that he is suspected to have disclosed state secrets through Hong Kong's Yahoo. So his email was intercepted. Yahoo Hong Kong disclosed his IP address to the mainland authorities. And it then became an international news. You think that it's just superficial interception. Let me just talk about the IP address. It seems that it's nothing serious. However, this is a fundamental human rights issue. Yes, you talk about child pornography, naked chats. They are serious social problems. but the public does not know what kind of standards you are using. So for ordinary people's WhatsApps, and for people who just say something on the social media, then you think there is a problem and you start investigating. Well, in my ears, this is a very serious issues. I don't think the triers would plan their bank robbery through WeChat. They would always use codes. So for any more in-depth communications, they would use codes. So what kind of standards will you be using? You're saying that the bill has clearly stated that for all these actions, they need authorization. But however, there are many covered operations. If you make all these operations public, then the criminals would know. So for the authorities with power, they can do whatever they like, and they can intercept when they find it necessary, right? Well, for the executive, we do not want to use ambiguous terms such as superficial or in-depth to describe the action of interception. Well, for a public officer, if he is to enforce the law by interception, he has to comply with the relevant sections, and in particular Section 3. Section 3 has stated very clearly under what circumstances an LEA officer will be allowed to do this. It must be a serious crime. It must be for public safety, and a judge would have to look at it. And if there are no other means than interception, then you may be granted the right to do it. And you must also look at proportionality. So there are a lot of restrictions and controls. I don't agree that the power is limitless. Yes, he is powerful. However, there are also very stringent requirements. And for the warrants, it's about another ordinance. It's not this bill. I can give you more information if you want. However, it doesn't mean that it's very easy to get a warrant. You have to take an oath. You have to apply to a magistrate. The magistrate would have to look at everything. So all these will be scrutinized in great details. Now, if it's a non-public officer, and if he intercepts, then he's not governed by this bill, because for this bill we're talking about public officers. Yes, we understand that you are very concerned about non-public officers. For some organizations, maybe certain people are doing this and that, and you've been eavesdropped, etc. Actually, the Law Reform Commission issued several reports a number of years ago. That is, for the interception carried out by non-public officers, there were a number of reports. I think another bureau is looking at this, because this is about privacy infringement, and this would go under the privacy policy. Another bureau is looking at it. If members are concerned about this, you may want to look at the progress of their study. However, at the moment we are talking about crime investigation. This is different. Ms. Mo just entered the room. Previously, we have had a lot of discussions about WhatsApp. Those issues we have been talking for a while. You don't have to worry that this bill covers too much or too little. It does not have a list of social media. When a message is transmitted electronically, then it's covered, and the coverage is broad. When that bill was formulated, the definition was quite broad, and it was agreed on by members and administration. And if in the future there is a need for amendments, we will come back to the LegCo. I think we have focused our discussion today on this issue, that is asking the ISPs to provide user information and applying to the court for warrants. We have spent 2 hours on discussing these 2 issues today. The government has undertaken to provide more relevant information to us. At the next meeting, we will have more discussion when the government provides us with another paper. But the government has made it clear that they will not make the ICSO's coverage wider. When it comes to getting information from ISPs, this is a matter of application for warrants, and it may involve other ordinances, for example, Prevention of Bribery Ordinance, Organized Crimes Ordinance, etc. So the coverage will be much broader. Mr. James Toh wants to expand the scope. Under this piece of legislation, we can talk further about this. And also for the application for warrants at cost, we can also talk about whether that can be made more stringent. However, I think our discussion should be more efficient. Ms. Emily Lau, on the 30th of April, the Hong Kong Journalists Association sent a letter to the government. Has the government replied to that yet? Betty, our clock. No, that hasn't been done. Well, it's time's up already. So can the government give us that reply at the next meeting? Well, there are questions asked by other organizations. So can you also give us those replies, please? When is the next meeting, Chairman? AOB. No AOB. Next meeting, 19th June, Monday, 2:30 p.m. Thank you. The meeting is adjourned now.